Hey guys, I have a real exciting episode for you today. I interviewed an attorney that's talking to you about intellectual properties, but she's going to get into some really, really deep conversations. I think you're going to love this episode because if you're a small business out there and you don't think you need any type of IP, I really, really need you to listen to this episode because I'm thinking it's going to change your mind. So without further ado, enjoy the show.
Hello and welcome to Marketing Solutions for Local Law Firms, the podcast that provides you with all the latest digital marketing tools, tips, and strategies you will need to implement in order to stay ahead of your competition. If you are looking to substantially increase your caseload in the next 6 months, this is the podcast for you. And now, here's the host of our show, the local business guy himself, Frank Deming.
Hello, everyone. This is Frank Deming, the local business guy. Welcome to another episode of Marketing Solutions for Local Law Firms. Happy Wednesday, everyone. Happy hump day. I hope you guys are having a rockin' week thus far. Today, I have the privilege, as I said in the pre-intro, to introduce you to yet another attorney because it's Meet the Attorney episode, as I do at least twice a month. So I can expose you to as many attorneys as I can so you can see what kind of great services they are providing. Today's episode is no different because I'm going to introduce you to the great Nancy Delain. How's it going, Nancy?
It's going just fine, Frank.
Awesome. Nancy, I said a couple of things already about you in the pre-intro, but in your own words, who are you and what do you do?
My name is Nancy Delain, and it is my privilege to help you nurture your mind child. Now, what might a mind child be?
Good question.
Well, I know it's a good question. People are always asking me that question. What's a mind child? So my response to this is think about what comes out of your mind. What does come out of your mind? Ideas, right?
Mm-hmm.
Okay. So if you have an idea, that idea in and of itself, while it sits in your head, is not something I can do anything about. Okay, I am not the thought police. I cannot read your mind. Nobody else can read your mind when it's not expressed when it's not, while that idea is still in your head, it's simply not protectable. However, once you express that idea, and there are many ways to express an idea, it may become protectable. If you express that idea in terms of an invention, it becomes protectable as a patent or a trade secret. Maybe sometimes both, and they do work very nicely in tandem, believe it or not. A patent is an exercise in disclosure, a trade secret is an exercise in keep your mouth shut, but you can make them work together. If you express your idea in terms of some sort of a work of authorship, a book, a piece of music, a sculpture, a painting, a pantomime, a dance, whatever, something that qualifies as a work of authorship, then all of a sudden you're into the world of copyright. And I will point out that copyright is a very powerful means of protecting things. There's a lady in England who went from being a welfare mom to being a billionaire mainly through copyright. She also has some trademark. Her name is J.K. Rowling. I'm sure you've heard of her.
Yes.
And if you express your idea in terms of something that increases your business goodwill, then you're into it. Then you're into the wild and woolly world of trademarks.
Gotcha. Awesome. So, the name of your firm is Delain Law Office, correct?
That's correct.
So is it just you, Nancy?
It is just me. I am the chief lawyer and I am the chief janitor. I'm working to change that.
How long have you been in practice?
I graduated from law school in 2003 after spending 20 years as a technical writer before I went to law school. And I passed the New York State bar right out of the gate. And then I sat for the patent bar, passed that right out of the gate. So now what I do is a subset of technical writing, in which I have a master's degree, and I write patents and contracts all day long.
Interesting. So basically, you're solely an IP or intellectual property, if you will, attorney, right? That you
I
don't
also
know.
do some business law.
Okay.
Contracts. And there are some interesting intersects between intellectual property and business law. For example, contracts. Contracts govern the way intellectual property gets used, gets licensed, gets shared, gets disseminated.
Gotcha.
So I spend a fair amount of time writing contracts and reading contracts and evaluating contracts. So
I could definitely see the correlation between those two things. So I'm gonna head off. I have a couple of questions about you because your line of law is well, maybe for you it is, but for me it's not very common. And probably some listeners it's probably common for them too, but you never know. There's some people who may not. So I'm gonna ask you some questions here that are pretty basic. Maybe to use basic, but maybe some people will need to know about these things. So my first question is actually 3 questions in one.
Okay.
See if you can rattle them off real quick for me. The first question I have for you is, number 1, what is a patent? What is a copyright? And what is a trademark? The reason I'm asking you that is because I recently just did a whole trademark on my logo and slogan. And I was really confused with the documentation, but anyway, so if you could just help me out and tell me what are the differences between those 3?
Sure. Going in order, a patent is, all of these things are nothing but bundles of rights. Okay, that's what they are in actuality. The question is, what bundles of rights are they? A patent is a bundle of rights. It's granted by the federal government. You get a patent through the U.S. Patent and Trademark Office in the United States, and every country has its patent office. Sometimes they're combined with the trademark office, sometimes they're not. But the USPTO, when you receive an issued patent from the USPTO, it is good within the United States, and it gives the patent owner the right to exclude others from making, using, selling, offering for sale, or importing that patented invention. Notice I did not say it gives you the right to do the invention. It gives you the right to exclude others from doing that invention. And that's an important distinction because a patent is basically a monopoly. We have laws called antitrust laws. Patents run afoul of antitrust laws all the time, but a patent is guaranteed in the body, not in the body of the U.S. Constitution. It's not often some amendment like free speech is. Okay, it's in the body of the Constitution. Same is true of copyright. Okay, but a patent, we have to kind of reconcile the patent monopoly with the fact that we really don't like monopolies. Okay.
Yeah.
And we do that by limiting the term of the patent, and it is a strictly limited term. That patent is good for, depending on the type of patent, it's either 14 or 20 years. Most of them are good for 20 years after the date you file the patent application. And there are some extensions that are available, but they usually have to do with some agency holding the patent with some federal agency holding the patent application up. Like, for example, a drug patent would have to pass muster with the FDA, and that process would stay the patent, the time frame for the patent application. But it's a patent is a bundle of rights that gives you the right to exclude others from making, using, selling, offering for sale, or importing an invention. Quick
question before we go to copyright.
Yeah.
Is a patent only on tangible things, like a patent piece of like material, for instance, on a clothing line, or maybe a particular component that goes on computer? Is that a patent stuff, or is that?
Those are usual. Yeah. Tangible things are the things that are generally protected by patent. Gotcha. But there are intangible things that are protected by protected by patent as well. Things like processes and procedures can be protected by patent. For example, as long as that intangible thing transforms something that's tangible. For example, I have a client who has a patent, and I got her this patent, and I'm very proud of the fact that I got her this patent, that takes a group insurance product that's used for travelers insurance for people who are traveling for things like the Peace Corps. Okay, they're volunteers going off on some do-good mission. Okay, and usually these insurance products are group things, and you can't modify them. But my client came up with a method, a procedure for modifying that group insurance thing and allowing individuals to modify to have the equivalent of an individual policy under the group.
Gotcha. Wow. That in and of itself, you need an attorney for. Anyway.
And she knew it.
Oh, awesome. So I cut you off there. You were on a roll to talk about copyright. So go ahead.
Okay. Copyrights give an author, somebody who creates a work of authorship, certain rights. They have the right to copy their work. They have the right to distribute their work. They have the right to perform their work. And these are exclusive rights. So when you go online and you go, oh, that's a really cool artwork that I'm seeing on Facebook, I'm going to copy that. Copyright infringement. You don't have to profit from the copy. All you need for copyright infringement is a valid copyright and a substantially similar copy. That's it. There's nothing about money in there.
So copyright can be an image. It can also be content.
It can be content, absolutely. Images, sculptures, ballets. George Balanchine held copyright in much of the New York City Ballet repertoire because he designed it.
So when you go to some of these websites talking about images, because this recently happened actually, and the image says royalty free. That means you can download that without any copyright.
You don't have to. The copyright attaches. The copyright is there. You can download it You can download it and possibly use it royalty free, depending on the license that particular website is granting. And you don't have to pay royalties for it because that particular author has granted the image to the public domain.
We'll be back after a quick break.
Hey guys, I hope you guys are enjoying today's content. While I have you on here, I want to introduce you to a promo that we have going on for the spring of 2024 for all legal practices throughout the U.S. I have an outstanding offer that we've never been able to offer before, but we want to do it because you have been an avid listener. We're only promoting this to people who listen to the show. So if you're an attorney and you are an avid listener to the show and you're thinking about possibly opening your own practice, you want to pay attention to this announcement. We are offering a full website with hosting, SSL certificate, online booking service, online appointment management, and more, and much more, with a 1-year maintenance, all for $2,250. That's $2,250 one-time fee, and you have a full-fledged website. If you want to know more about this, just give us a call at 888-416-7752 or send us an email at info@lbmsllc.com. Just make sure that you mentioned that you heard it on the show, and we'll definitely get you that discount. So with that, I'm going to bring you back to the content. Yeah, like iStock or whatever.
iStock is not always free. You get
No, I know it's not free, but I mean, so let's say I pay a subscription for iStock and I get all the images, so I'm good. I can
right. Once you pay that subscription fee, but what you're doing when you pay that subscription fee, that's a licensing fee, and iStock then turns around and pays, they collect the artist's fee for the use of the work, plus a commission for themselves for
hosting it,
for getting the work out there and getting it sold.
Gotcha. Interesting. Now, how about a slogan? Can you copyright a slogan?
You cannot. A slogan is actually too short. If you look at my slogan here, nurture your mind, child.
Mm-hmm.
That is not a copyright symbol at the end of it. I know you can't read it very well.
That's a registered trademark.
That's a registered trademark.
Yeah. Gotcha. Interesting. Very confusing.
Slogans tend to be used in conjunction with business goodwill. They fly the friendly skies. Where's that come from? You know where that comes from. Fly the friendly skies.
Isn't that United?
Yeah. Or just do it.
Oh, that's Nike. Yeah.
That's Nike. That's right. Or let's see what other. Where's the beef? Remember that one? That's an old one.
Yeah. Where's the beef? That's that lady.
Burger King.
That was a great commercial.
Those, and you notice how quickly you associated those things. And that's the point of trademark. Okay. To get people to associate the slogan or the image with the business, with the source of that good or service in the stream of commerce, and just make that association immediately.
Gotcha. So we just went into trademark without even asking. Okay. So, now, before I ask you the next question, how does all of that stuff work together? Like, for instance, you can patent. So basically, if I have a product, like for instance, this mug here that you're looking at, I want to patent that. I can patent the mug, the material that's in the mug.
That particular mug is probably not patentable, but
right.
If I were to come up with a new computer design, okay, I could patent my new computer design.
Mm-hmm.
Then I'm going to have documentation to describe that new computer design. That's copyright. Then I'm going to have to name that new computer design something. It'll be called. It's not going to be called Apple because that one's already out there. But I might call it Nut Job Computer Design. Okay. Right. And Nut Job would be a trademark of that computer design.
So then you go full circle there. So now you're totally protected. Yeah. So now you mentioned the amount of years for a patent. You said it could go up to like 20 years, you said, or 10 years?
A utility patent, which is the type of patent that we usually think of when we think of a patent. That's the widget, the better mousetrap, my client who had the process to do the insurance thing was that was a utility patent. Okay, gotcha. Those are 20 years from the date of filing the application.
Gotcha.
Okay. They are not renewable. You cannot renew a patent.
Oh, really?
The same argument applies. Antitrust. Patents are monopolies. We don't like monopolies.
So then you got to do something else after the patent.
Well, yeah, this is where trade secret comes in. Okay, you have to when you file that patent application, you must disclose the best mode of making and using that invention as of the date you filed that application.
Gotcha.
Very important words there. Okay.
Gotcha.
The date you file that application, that's the cutoff date. If you make some improvement on that invention the day after you file the application, and that improvement is something that you can, kind of keep under your hat and not tell the world about, that improvement becomes a trade secret. And by having that improvement in place on that invention, you can effectively extend the life of the patent.
Interesting.
Because, people are going to know how to make and build what you disclosed, but that trade secret's there.
Tricks of the trade.
You've got kind of an upper hand on the competition once the patent expires. Also, you will have trademarked your invention. You will have given it a name. You will have registered the trademark. And 20 years is a long time.
Yeah, it's a long time.
A long time to, you will have built that brand up in 20 years. So patent expires. you can continue to market the invention under your brand, and you'll have a little bit of a market edge there because you're the familiar name.
The first name, yeah. What about copyright? Is there a period for that?
There is. Copyright is very long lasting, and it also is not renewable, but it extends from the life of the author plus 95 years. So why would you want to renew it unless you're a company like Disney?
The life of the author plus 25
plus
years?
95 years.
95 years.
95 years.
So basically it's a lifetime.
More than.
Yeah.
It's the lifetime of the author plus the author's grandchildren.
The grandchildren, yeah. I happen to know a little bit about trademark because I went through the process, but why don't you tell me what is that limitate? How long is a trademark good for?
Trademarks are good for, well, it depends on where you're registering them. Okay, trademarks are a creature of both federal and state law. If you register federally, which means that you are in interstate commerce, you're engaging in commerce between at least two states. Okay, and you go to the U.S. Patent and Trademark Office, and they give you, they register your trademark for you, and then you have 5 years. Between years 5 and 6, you must re-register the trademark with proof of continued use of that trademark. Okay. Then again, between years 9 and 10, you must re-register that trademark with proof of continued use. After that, it's every 10 years. But you can renew a trademark, and you can renew that trademark for an unlimited period of time, as long as
yeah. That was the letter we got when I filed. Yeah. So I mean, if you look at my logo, you'll see the R on it now. So I trademarked the logo and the slogan. So
congratulations. I did the same thing. There's a little R in a circle there next to my logo, and a little R in a circle there next to my tagline. Yeah,
it's a beautiful thing. All right. So I mean, this is all interesting because I'm gonna be straight up honest with you. I never thought it was a need for it until I ran into someone similar to yourself. But I wanna ask you a question that I asked this person. I'm just kind of curious if your answer to this. I just want to know, why should you even bother to protect your company's intellectual property? What's the big deal about it?
Well, there's several big deals. First of all, there's the pride of ownership. It is yours. Okay. It's especially with something like trademark. Okay. You want to distinguish yourself in the marketplace. You want to be unique. You want to, you don't want, there are piles of podcasters out there, Frank, and you don't want to be confused with another podcaster who does a show similar to yours. You want the two names to be different enough so that Frank Deming's podcast is very different from, say, Joe Schmo's podcast, and where Joe Schmo and Frank Deming both interview lawyers. And you don't want people to get confused between Frank Deming and Joe Schmo. You don't want you want those two things to be separated.
Makes sense.
And there's value in that. Trademarks are licensable. And if you put a system with a trademark, all of a sudden you've got a franchise, and there's something that can be a very valuable commodity. I mean, I'm going to pick on my favorite example. There was a hamburger stand in California in the 1950s, and it developed a trademark. It had golden arches, and it was run by the McDonald's brothers. And a guy named Ray Kroc came along and shook it by the scruff, turned it into a multi-billion dollar international corporation. That's trademark. That's all trademark.
Gotcha.
And that's one reason to protect. It's profitable, and you want to keep it yours. Okay.
Now before you continue, what happens if you don't protect? Let's say, okay, let's keep the McDonald's example. He's got all of these. I'm assuming he's patented the patties, right?
I have no idea whether he patented the patties or not, but let's assume he did. Let's say he patented his process.
His process, yeah.
His process for making the patties.
For making the patties and all that kind of stuff. And so let's just assume back in the 50s, he didn't do all this stuff. He didn't know someone like yourself to tell him, hey, you should do this. What's the worst that could happen, that could have happened to him? That means someone can just come up and steal it and claim it to be his or hers, or
that can happen. I actually have a couple of clients who are in that situation right now. They failed to register their marks, and other people are using their marks or something confusingly similar to their marks, and it's a problem. It's a problem. One of them, I don't know, and I don't know if we're going to be filing a cancellation for the mark that got registered out from under. The other one, I'm pretty sure we're not. Those folks are in the process of coming up with other trademarks because they're fairly new in business. But the one that the one I'm thinking might do well to challenge the existence of the registered mark. She's been in business for a while, and this registered mark came in and just came out and registered out from under her because she hadn't registered her mark. And gotcha. now she faces the distinct possibility of losing the right to use her own trademark, and she's been using it longer than this other company has. So.
Yeah, I can see the argument there. I mean, anything can happen. If you come up with a really good idea and your brand is really, making inroads out there, yeah, you want to protect it, especially since, someone can actually come. No one ever thinks about that. I can tell you, I never thought about that. And I just thought, hey, why would someone want my name? Why would someone want my brand?
The last piece of litigation I did, I am not a litigator, but the last piece of litigation I did was between two construction companies. One of them is a well-known construction company that is in my particular area. The other one is a lesser-known construction company that was one county over. The owners named their companies after themselves, okay, and they both had the same last name. So we had one really good company X and another not so good company X. So people were starting to confuse the not so good company X with the good company X, and the good company X was actually losing market share because of this. Because all of a sudden there was a bunch of buildings out there that were constructed not to company X's standards.
Yeah, I could see that could be a problem.
Yeah.
So, out of curiosity, I have a lot of people who listen to me who are attorneys just like yourself, but I have another audience that are small business owners that listen to this, and I know they're probably scratching their heads like, okay, this is interesting. You can protect it, but businesses, as you know, Nancy, are all about making money, right? So. Just curious, how can like I make money? How can another small business make money, from intellectual properties?
Again, depending on the type of intellectual property. Okay. Patents. You can license them. You can sell them outright if you want to. But there are all kinds of ways to license a patent. You're going to get money either way. If somebody wants to purchase your invention, they will pay you money for that. Sometimes they pay you a lot of money for that. Okay. If somebody wants to use your invention but not necessarily own all the patent rights to it, then they will license your invention, and you can write a license. A license is a contract. Okay, you can write it however you want. You can limit the contract. You can give them all exclusive rights. Okay, that's basically abdicating your patent. But you can also say, okay, you have the right to use this invention in New York State for 5 years. You can limit it in terms of geography and time. Okay, you can limit it in terms of who gets the patent right? If the licensing company goes out of business, what happens to that? Does it revert to the patent owner, or maybe there's some clause in there that says if the licensing company the company that licenses the patent goes out of business, there's a successor company that's all lined up to take it over. There are all kinds of ways to write this thing. Okay. The same is true with trademark. Franchise companies make a chunk of change through the licensing of their mark. Okay. When you pay a franchise fee to McDonald's,
right.
and that's an extreme example. McDonald's charges a massive franchise fee, and not all franchise companies do. But when you pay that franchise fee, you are licensing the use of the mark, and you're paying for that, for the right to use that trademark and that system.
Right.
Okay. With copyright, when you purchase a book, when you purchase a piece of artwork, that's through copyright that you're licensing you don't own the copyright in the book when you buy, and I'm going to pick on J.K. Rowling again. When you buy Harry Potter, you do not own the copyright in the book. You own a copy of the book, and you have
correct.
Okay. And don't think J.K. Rowling doesn't get a cut of every first sale of Harry Potter that's out there.
I'm sure. Interesting. So, all right. So those are all good examples of how to make money on this thing. Now, out of curiosity, what are the what's if I was to start a new business today, and it's, I don't know, it's a software company. I'm a software guy, so let's go with that.
Okay, we'll go with
it's a software company. It's a SaaS company. You're familiar with that term, right?
Yep.
Awesome.
Sure. Software as a service. Got it.
Right. I'm starting a SaaS company. What advice as an attorney, as an IP attorney, you would give me starting a SaaS company?
Don't patent anything. Literally. When software can be patented,
okay,
as long as it transforms something. But when you write a software patent, you must disclose source code.
Oh, really?
Yeah, you must disclose the best mode of making and using your invention as of the date you file that patent application. That means source code. Okay, so you're giving people the keys to the kingdom when you patent a piece of software. Okay. But if you instead you compile this source code into object code, and you do whatever magic you do to keep people from being able to reverse compile it, then you've got a really nice trade secret that'll last for however long you want it to last. Okay. By all means, invest in trademarks. Okay. Be clever with your name. Do not name things according to what they are. Okay. For example, there's a tree out there. Okay. It grows fruit. And this fruit is it's red usually, and it is purported to keep doctors away. It does not have chips. It does not have microbuses. It does not have ports. It does not play music. Apples grow on trees. They are not computers. So if you name your, and yet Apple is a very strong trademark for a computer company.
Yeah.
Okay. So name your software. Don't call it Frank's Software. Don't call it Frank's SaaS. No, don't do that. Just name it. Find some clever name for it, and name it that. And if you can make up a word to name it, by all means, please do. Strongest trademark in the business. Okay.
Yeah. It's funny you say that, because when I first started my business, I called it, ready for this? Deming Inc.
And there's nothing wrong with that. There's nothing wrong with that. If you name your software Deming Software, that's okay, because Deming has absolutely nothing to do with the software and what it does.
Okay.
Okay.
So I could have left it like that then.
You could have, yeah.
This has all been great, Nancy. quick question for you. What is the website? If someone wanted to get a hold of you, wanted to find out about all about your services, what's the website?
Well, if you're watching the podcast, you can see it on the bottom of my little frame here. It's ipattorneyfirm.com.
ipattorneyfirm.com. I will put that in the show notes, so that's not a problem. I will also link out to your LinkedIn. I believe you and I are connected on LinkedIn. I would like to show have other people connect you on LinkedIn. Now, I am assuming, I know you're in the state of New York, but you can do IP work for anyone throughout the US, correct?
My most distant client is in Dubai.
Oh, so throughout the world, not just the US.
Not just the US. As long as the world is trying to come into the US, I can help them. Okay.
Oh, okay.
You know, I can't file a patent in the United Arab Republic. I'm not admitted there. I can't even file a patent in Canada. I'm not admitted there either. But I am admitted in the United States. And if somebody wants to come into the United States with a piece of intellectual property, I can help them do that.
Awesome. As you know, this is a marketing show, Nancy. Out of high level, what do you do to get most of your clients? What's your not a secret, but I mean, what's your method?
I appear on podcasts like this one, Frank.
Gotcha.
What else do I do? I'm fairly active on LinkedIn. I have a YouTube channel. I have a TikTok channel, which pretty much duplicates my YouTube channel. But different strokes for different folks.
That's smart. That's very smart.
And I post like 5 videos a week on YouTube and TikTok, and then I share those videos on LinkedIn, Facebook, and Twitter.
There you go. That's awesome. As a marketer, I am so happy to hear you say that. All right, so this pretty much puts an end to the episode. But before I let you go, is there anything that I did not ask you that you think will benefit the audience?
If you have an invention, do not talk to anybody about it until you talk to your intellectual property lawyer. The reason I say that is because there is a statute in the United States. It's called 35 United States Code 102B. And we call this the 102B bar. The 102B bar says that once you disclose an invention, you have 1 year, not 1 year and 1 day, 1 year to file the patent application, or you donate that invention to the public domain. It will not be patentable after that time. So
what if someone signs an NDA?
Doesn't matter. Talk to your patent lawyer before you disclose to anybody.
Gotcha. And if you don't have a patent lawyer, you speak to Nancy, and all her information is on the show notes. Go there right now. If you have an idea and you want to protect that idea, reach out to Nancy Delain, because you will be well served. So that will put an end to this episode. This has been a great episode. Thanks, Nancy, for coming. This has been Frank Deming, the local business guy, and you've just been blessed by the great Nancy Delain. Take care, everyone. Until next week. Peace out.
Thanks for listening to another episode of Marketing Solutions for Local Law Firms, the podcast that provides you with all the latest digital marketing tools, tips, and strategies you will need to implement in order to stay ahead of your competition. If you would like to know more about the topic we discussed on the show today, reach out to Frank and his team at 888-416-7752 and schedule a discovery call with one of the marketing consultants. If you'd like to be a guest on our show, send an email to podcast@lbmsllc.com and we will put you on the schedule. With that being said, until next week, make it a successful digital marketing day. Peace out.